Hi, everyone. I'm Doug DeVos, and welcome back to Believe. Today, my guest is Jeff Rosen. He's the president of the National Constitution Center, and his work has empowered tens of millions of people to better understand our country's history and purpose. So I want to know, and I've loved to know, who cares about the Constitution? Does it still matter today? And how does it affect all of us as individuals and citizens? Well, I've wondered about this a lot, and I just love this topic. I'm so curious about it. So let's see what Jeff Rosen believes.
We believe, and have always believed in this country, that man was created in the image of God, that he was given talents and responsibilities and was instructed to use them to make this world a better place in which to live. And you see, this is the really great thing of America.
It's time to discover what binds us together, and finding it has the power to transform our world. That's what I believe. How about you? Well, hello, everyone, and welcome to Believe. I'm Doug DeVos, and we're thrilled to have you back here with us again. Today's topic is a wonderful topic, and I'm really excited to dive into it. We're going to be talking about something that impacts every American, and that's the U.S. Constitution. And the question is, how does it really affect you? It is the guiding document for our country, and you may hear a lot of things about it here and there, but a lot of people may not know the ins and outs, or may not know the history of it, or how it really is alive today. So our main question is, who cares about the Constitution? Do you care about the Constitution? Do you believe that it's important in your life and for the good of our country? So where do you stand on this? We're going to have some fun times to talk about this, to dive into it. And I've been on an adventure here with the Constitution for a number of years. I've been absolutely honored to be on the Board of Trustees of the National Constitution Center in Philadelphia. And we're here today with the center's CEO, Jeffrey Rosen. And Jeff is not only a fabulous CEO, but he's a good friend. And I just so enjoy talking with him about these issues and what's happening here in our country. And when we get together as trustees, there's so much passion around the topic of the Constitution and around our country and how we believe in our country. And we are from all sorts of different political backgrounds. But that has never stopped us from unifying around the Constitution and what it means and how to share and talk about it, so we can try to answer that question a little bit of who cares about the Constitution. And we hope, as we go through this, that you'll have a new appreciation and understanding. So, Jeff, welcome. We're so happy to have you on the show here. Thank you for taking the time to join us.
Thank you, Doug. It's wonderful to be with you.
All righty. Well, Jeff, we're gonna dive on in, and this is kind of reflective of conversations that we've had over a cup of coffee or at dinner or over time over the years, because I continue to be just so curious about this document. Maybe just start with framing things a little bit of how does it fit in? Because maybe for some of our audience, that pathway from the Declaration of Independence through the Revolutionary War to the U.S. Constitution, a lot of stuff happened in those years. There was quite a span of time, and just maybe how the development and the establishment of the Constitution was so vital for the starting and the founding of our country.
Well, thanks so much for asking, Doug. It's wonderful to be with you. We've been on a journey together as we strive to educate Americans about the Constitution and empower all Americans to teach themselves about its fundamental principles. So it's so meaningful, as you ask, to say, what's the connection between the Declaration and the Constitution, and what happened during those crucial years between 1776 and 1787 to enshrine the core of American ideals into the greatest document of human freedom in history. So let's see how fast I can do it. Let's give the condensed version. We've got to start in 1776 with those inspiring words of the Declaration, which we all know by heart. All men are created equal. They are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men. In those beautiful clauses are contained three big ideas: natural rights, popular sovereignty, and the rule of law. And that's the core of the American idea. So let's quickly parse them, and then we'll show the connection with the Constitution. Natural rights. Our rights come from God or nature, not from government. They're inherent in who we are. We have them as human beings, and they're universal rights. What are those rights? Well, they include life, liberty, and the pursuit of happiness. Those rights are unalienable. What does it mean to have an unalienable right? It means I can't alienate or surrender it to you, Doug, or to government, or to anyone else when I move from the state of nature to form a civil society or a government. What's an example of an unalienable right? The most basic one is the right to conscience, the right to free exercise of religion, the right to form my own beliefs about the nature of the universe. Why are my beliefs and thoughts unalienable? Because they're the product of my reason. And as the product of my reason, I can't command myself or anyone else about what to think. Our thoughts are the product of reason, and I can't surrender my reasoning powers to you. And that's why the right is unalienable, and that's why the rights of conscience and the rights of religious belief are among the first of our unalienable rights. The other ones are life, liberty, and the pursuit of happiness. And I form governments to secure those rights. And that leads to the second big idea, which is popular sovereignty. Because we're all born free and equal, everyone has an equal right to consent to government. And because government is based on consent, the ultimate power resides in we the people. And we the people are the rulers, our representatives are just our servants. And anytime our representatives are not doing what we like, we can recall them with new elections. And if the government is threatening our rights rather than protecting them, well, the Declaration says we have the right of revolution, and that's what the American Revolution was about. And the final idea is the rule of law, that in order to secure our rights, government has to operate according to laws that are predictable, transparent. It can't treat you differently than me because it doesn't like you, and vice versa. And we have to ensure that all of our rights are judged by fair procedures, trials, due process, and the government can't act arbitrarily. It's the opposite of a despot, is to have a magistrate or a president or Congress bound by the rule of law. So those are the three big ideas. We can talk about the transition from the Declaration to the Constitution, but I think I've been talking long enough. So what do you think of all that, Doug?
Well, I think our audience knows exactly why you're the perfect person to talk about these sorts of things. So thank you for that, and how important it is to understand not just what those words are, but the ideas behind those words. What was the mood, the environment and the thought that went into choosing those words and what they really mean and why they've been so timeless. But talk about how those words, they started a revolution. We got on that track, but we had to find a way to secure and to land a framework under which all these things could happen, where we could preserve our natural rights, where we could establish popular sovereignty, where we could establish the rule of law. And that was the Constitution, because the Articles of Confederation didn't cut it. Talk about that a little bit.
Exactly right. And I'm so glad you picked up on that word, secure, to secure these rights. That's why governments are instituted among men. And as you said, the Articles of Confederation didn't cut it. The Articles of Confederation were a loose treaty that treated all the states as sovereign. The states are very keen to maintain their power, and as a result, they made it very hard to do anything. You needed unanimous consent of all 13 states to do anything important, and that made it impossible to raise money to support the Revolutionary War, to achieve common defense, or to make treaties. And as a result, there was a lot of uncertainty and inability to have commerce and an inability to pay the war debts. That led to an economic crisis, and it led to civil unrest, and in particular, it led to mob violence. And it's really important to emphasize how important this fear of mobs, animated by passion rather than reason, was the driving force for the ratification of the Constitution. So the big mob that really got everyone upset was in 1787 in Western Massachusetts. There are a bunch of farmers led by a guy called Daniel Shays, who are upset because they can't pay their creditors. They fought in the Revolutionary War, but they haven't been paid because there's no central government to pay them. There's a lot of inflation. And they're so upset because they're being charged with bankruptcy that they mob the bankruptcy courts in Massachusetts and they try to shut down the courts. And that really gets the framers' attention. And James Madison is so alarmed by this vision of mobs shutting down government buildings that he writes in Federalist 55, in all large assemblies, if any character composed, passion never fails to wrest the scepter from reason. Even if every Athenian had been Socrates, Athens would still have been a mob. What he's trying to figure out is how you create a government that is constrained enough to protect rights, but also powerful enough to achieve common purposes and to avoid the mob. And Madison's great innovation, and this is his central contribution to our political thought and to the American idea, is to turn classical political theory on its head. The conventional wisdom had been you could only have republics or representative democracies in small areas where everyone knows each other, where they can deliberate and they have common purposes. Madison says, actually, it's the opposite. It's a real advantage that America is so big. Because the country is so big, it'll be hard for mobs to discover each other, to organize. And by the time they actually find each other, maybe they'll all get tired and go home. A large republic, Madison says, will ensure the slow diffusion of reason. And Doug, in your introduction, you used another really important word. You talked about the passion that you and I have for, educating people about the Constitution. Passion can be good, but only when it's filtered through deliberation. And we have to use our powers of reason to moderate our unreasonable passions like anger and remorse and jealousy and revenge in order to achieve cool deliberative reason. This comes from Aristotle and Plato and the Stoics and classical political theory that need to triumph of reason over passion. So the whole Constitution is designed to slow down deliberation so mobs can't form, as they did in Shays' Rebellion, and that reason will slowly prevail. And that's why our Constitution sets up such an intricate, complicated set of mechanisms. Power resides in we the people. That's what the preamble says, we the people of the United States, in order to form a more perfect union. But we parcel out our power temporarily to a bunch of different places. Congress has some of it. The president has some of it. The courts have the ability to ensure that all laws are consistent with the Constitution. And then there's a vertical division of power also between the states and the federal government. All this is to ensure that no one branch is allowed to speak for we the people. Who speaks for we the people? The Constitution does. This was the great genius of the framers, to say that because the Constitution is passed according to special procedures, you have to submit it to special ratifying conventions. You hold special elections for those ratifying conventions. People have to deliberate extensively over time to make sure that it really represents the considered deliberative views of we the people. That's why the Constitution speaks for we the people and not our temporary representatives in Congress. The people in Congress are just the Hamilton used the word servants. We are the masters, they are the servants. And anytime there's a clash between the will of the people and the will of our representatives, courts should prefer the master to the servant, the principal to the agent. That's what Hamilton says in Federalist 78. So, wow, what an extraordinary innovation and application of all of this wisdom the framers had. And that's the gist of the goals of the Constitution.
Oh, fantastic! Thank you, Jeff. You touch on so many issues, and I think I'm already knowing we're going to have many conversations because this is just so fun to dive into because the history is important. And today, people, it's easy to kind of go back and say, well, history's past, we're all about the future. That's true, but the lessons of history, and even our framers went back to Aristotle and Plato, and they thought about all these experiments that had happened in human history to try to learn the best. And I love how they innovated. they turn some things around and say, no, it can work in a big country. Well, I want to talk about some of those things that we may be facing now with mob rule and other sorts of things in a little while. But I want to stay with establishing a foundation for everybody as we're listening here, because there was a lot of conversation at the time with the Constitution that it didn't include the articulation of specific rights, that the Constitution was the framework for the operation of the government, and that the Bill of Rights was always talked about, but not included originally. It wasn't until sometime after that the Bill of Rights or how those two got connected. And so maybe talk about that jump to specifically calling out the rights of individuals as part of the Constitution through these First Amendments.
It's such an exciting and important topic. So, as you say, the original Constitution didn't have a Bill of Rights. Why not? A really important question. Well, James Madison said there were two reasons why he didn't originally include a Bill of Rights. First, a Bill of Rights is unnecessary. There's no reason to fear that Congress could infringe free speech because Congress has no power to infringe free speech. It's only granted limited powers, and therefore we don't have to worry about that. And second, Madison said it might be dangerous to create a list of rights. Because our rights come from God or nature, not from government, people might wrongly assume if you have a list of rights, that's all there are. And in fact, our rights are so capacious, so extensive that they can't be limited to a single list. So that was his original reason for not including a Bill of Rights. But there were vigorous objections from a group of founders called the Anti-Federalists. These are heroes with names like Elbridge Gerry of Massachusetts and George Mason of Virginia. And Edmund Randolph of Virginia, who refused to sign the Constitution because it didn't have a Bill of Rights. And in the face of their objections, Madison changed his mind. He was a practical politician. He was also at that point trying to win an election in Virginia. And he realized that the ratifying conventions were saying, yes, we'll ratify, but we want you to adopt a Bill of Rights as a condition of ratification. And faced with that objection, he said, fine. Now, what's so interesting here is that when Madison set out to draft a Bill of Rights, he didn't start from scratch. He basically cut and pasted from the Revolutionary era state constitutions and bills of rights drafted between 1776 and 1780, which was the Massachusetts Constitution. And if our friends who are listening just want to open up a world of learning, it's so exciting to go and examine those bills of rights, which you can find at the Constitution Center website, constitutioncenter.org. And you'll see that often it's word for word. The Virginia Declaration of Rights of 1776 is the place to start. Madison had it by his side when he drafted the Bill of Rights, and George Mason had it, and Thomas Jefferson had it by his side when he drafted the Declaration. And I won't go through the word-by-word comparisons, but you'll see that our free exercise of religion clause comes from the Virginia Declaration. Our Fourth Amendment protecting unreasonable searches and seizures comes from the Massachusetts Bill of Rights. And there's just so much consensus among the states about which rights are natural, which are alienable, which are unalienable, which ones should be protected, that it wasn't hard for Madison to come up with a list of, it was 12 rights that were submitted to Congress. His initial list had 19 rights. It's really interesting to see which ones dropped out and which ones were adopted. But 10 were finally ratified, and those are the rights that we call the Bill of Rights.
Fantastic. I mean, that linkage is just, and that connection and the arguing, or not the arguing, the discussion, the reasoned deliberative debate on this topic of how it was so important to include those. Now let's kind of start to roll this forward a little bit. One of the things I've so enjoyed at the National Constitution Center and talking with Jeff and trustees and other experts that I've had the honor of hearing from, learning from, was this struggle in our country to have everyone feel that those rights or these ideas applied to them. And when you go to the National Constitution Center in Philadelphia, and I would suggest everybody go visit the museum, it's magnificent. But the original, the welcoming, the welcoming, act that we have, right? That welcomes you to the National Constitution Center, articulates that right off the bat. There were some things, glaring things that we missed. Slavery. women's rights. There were some huge things where this idea or the promise of the Declaration or the Constitution or the Bill of Rights wasn't applied fairly, or wasn't applied to everybody. And I think, John, there's a couple stories that I remember, Jeff. We had a display there for the First Amendment, and we were talking about the freedom of religion, and you said, well, of course, it didn't apply to those of Jewish faith at this point. And I was shocked. I said, well, what do you mean? It says right here. No, but it wasn't. There was the application of it. And obviously, we have had additional exhibits and exhibitions at the Constitution Center of the 13th, 14th, and 15th Amendment, and of the 19th Amendment, and how this ongoing journey and this passion to say, hey, this applies to me, and that's kind of again where our country, our opening question comes from: who cares about the Constitution? We all do, because we all want to be part of this, but that's been a journey, and a tumultuous journey. Talk a little bit, if you can, about some of those steps and about what we've learned by understanding these restrictions or these mistakes, however you want to call it, from the beginning, and how we've tried to adapt through the Constitution to make sure that these words, these freedoms, these ideas apply to everybody.
Absolutely, Doug. You're so right to emphasize the crucially important ways in which those soaring ideals of the Declaration and the Constitution did not initially include all of we the people. And as you say, the most glaring and shameful initial omission was the omission or exclusion from enslaved people from the promises of the Declaration. What's so striking about the convention and the debates over the Declaration is that the founders knew this. Thomas Jefferson said, "I tremble for my country when I reflect that God is just." Other framers stood up and explicitly said that the system of chattel slavery was inconsistent with natural rights. James Wilson, the great founder who came up with the words of the preamble, "We the people of the United States," insisted that slavery was a violation of natural rights. Now, of course, at the initial convention, there were unfortunate compromises that were necessary to get the document ratified, and they included infamous clauses like the 3/5 clause of the Constitution, which counted enslaved people as 3/5 of a person for purposes of apportionment, to the fugitive slave clause. What's significant, though, is that James Madison said in notes that were discovered in 1840, when they were published, that the Constitution refused to insert in its text an explicit acknowledgement that there could be what Madison called property in men. In other words, the framers didn't want to explicitly endorse slavery, even as they didn't ban it. Madison and the other framers hoped that it would come in time to be extinguished. When Frederick Douglass read Madison's notes, published for the first time in 1840, and saw that the Constitution had refused to recognize property in men, he said it changed his own vision of himself as a man and as a citizen. And he changed his views about the Constitution itself. Previously, he had thought that it was a pro-slavery document, but after he read Madison's notes, he decided it was a glorious liberty document. And he said it was a libel on the founders to claim that they had endorsed slavery. And Douglass said that he wanted to call on the people of the United States to be true to the promise of the Declaration and to ensure that just as we recognize that all men are created equal, the system of chattel slavery would be abolished by constitutional amendment. And that's precisely what happened in the 13th, 14th, and 15th Amendments. So it's a very, of course, we're having a very meaningful and important debate in this country now about what we should think about the history of slavery in America, as well as the exclusion of other groups like women who couldn't initially vote at the time of the framing. What's so striking about American history is the more you learn, both the more you're struck by how serious the strife was. I mean, it took a civil war to end slavery, but also how consistently excluded groups invoked the principles of the Declaration and the Constitution to be included. Justice Ruth Bader Ginsburg had a beautiful word. She said that the Constitution was always becoming more embracive, by which she meant it was embracing previously excluded groups, not just grudgingly, but with open arms. And she argued, as history shows, that those previously excluded groups, from Douglass invoking the Declaration and his "What to a Slave is the 4th of July" speech, to the women's suffrage advocates invoking the Declaration in their Declaration of Sentiments in 1848, to Martin Luther King on the Mall, saying that we had to fulfill the promissory note of the Declaration and ensure that the Constitution guaranteed civil rights. All of these heroes and all invoked the ideals and called on America to be true to its best self. And slowly, in some cases grudgingly, but ultimately with open arms, as Justice Ginsburg said, that's exactly what happened.
So important to recognize, that journey and how bitter and how difficult it is. Anyone in life, any of us in life, if we're on the outside looking in, whatever that may be, it's so vital for us to understand that process. And one of the things that struck me, and Jeff, you have a wonderful podcast, the We the People podcast, and everybody, you should sign up and listen to Jeff on the We the People podcast from the National Constitution Center. Just brilliant. And you touched on it here, and I'd like you to dive in a little more deeply. When you talk about Frederick Douglass, and you talk about that speech, "What to the slave is the 4th of July," and the significance of that, and I want to pull out this idea that he goes back to defending and elaborating on the ideas of the Constitution, but making them real. And one of your guests on the podcast started to talk about how Frederick Douglass was I think, working with President Grant or challenging and with President Grant to say, just because the war is won, the work is not done. There's more to do, and it goes with the implementation of these ideas and the application throughout history. And while the 13th and 14th and 15th Amendment were ratified, it really kind of it had different journeys. We had a great conversation and with Dr. Gates about what happened in this time where things stalled and actually reverted because the application, the follow through from the 13th and 14th and 15th Amendments got stalled or didn't happen as it should. Can you talk about that a little bit more and help our audience kind of appreciate maybe that time in our nation's history and some of the things that were going on, and how somebody like Frederick Douglass, who was just so powerful, how he could still, even though he had lived that life, how he could still go back to supporting those ideas.
It's so crucial, Doug, and I love the fact that you're quoting Douglass, and we both believe that primary texts are so important to inspire us and remind and put us into the minds of the people who are experiencing this. So I'm just calling up my Frederick Douglass here. Here's from the "What to a Slave is the 4th of July" speech. This is kind of from random. This just pulled right up. What then remains to be argued? Is it that slavery is not divine, that God did not establish it, that our doctors of divinity are mistaken? There's blasphemy in the thought. That which is inhuman cannot be divine. Who can reason on such a proposition? They that can may, I cannot. The time for such argument is past. So Douglass is invoking the ideals of the Declaration, saying it's a violation of divine law, saying it's a violation of our natural rights, saying that the Constitution itself was a glorious liberty document, and insisting that it be amended to make the promise of the Declaration real. The 13th, 14th, and 15th Amendments are adopted between 1866 and 1871, and then something very painful happens, and it's very important to acknowledge it. and that's called redemption. Dr. Gates, Henry Louis Gates, as you said, came to the National Constitution Center. He's written some very important books about this period in American history. And it's just shocking, is the only word, shocking, to realize that after we fought a civil war, enshrined these amendments into the text of the Constitution, they were ratified at gunpoint in some cases as a condition for the Southern states being readmitted to the Union, and finally promised equal protection for all, ended slavery, and promised voting rights for African Americans. They were eviscerated by mostly political backlash, the refusal of the executive to send troops to enforce Reconstruction, the withdrawal of federal troops from the South after the Compromise of 1876, and the acquiescence of the Supreme Court, which in a series of decisions in the 1870s, when it struck down the Civil Rights Act of 1875, all the way through Plessy versus Ferguson, which so infamously upheld separate but equal, all completely inconsistent with the original understanding of the Reconstruction Amendments. So, and this is of course combined with armed terrorist violence where African Americans are lynched. We talked about mobs, and those mobs that the framers feared are now turned on African Americans, on the freedmen, on abolitionists. And just the most poignant, dramatic example, Frederick Douglass had thought that voting rights would be the king's cure to inequality. Just give the man the right to vote, and all will be, the promise of the Declaration will be fulfilled. There was this brief shining moment when there was meaningful voting in the South, and you have a whole bunch of African-American representatives in Congress, but then the promise is thwarted. Southern states introduced literacy tests, poll taxes, other ruses to stop Black men from voting. Suffrage plummets to negligible numbers. The Supreme Court upholds this complete attempt to subvert the 15th Amendment. And it takes almost 100 years till the Voting Rights Act of 1965 for meaningful voting to begin again. So this is an important part of our history to tell. It's not all a cheerful, uplifting story. But what is striking though throughout it all is there are dissents. There are Supreme Court justices ranging from the dissenters in the Dred Scott decisions to Justice John Marshall Harlan, who dissents from the decision to strike down the Civil Rights Act of 1875, and his immortal dissent in Plessy v. Ferguson, which is so inspiring to read, where he says, the Constitution is colorblind and neither knows nor tolerates classes among citizens. There is no caste here. So inspiring that Thurgood Marshall read that aloud before he argued Brown versus Board of Education to inspire himself for arguing against separate but equal, and nearly 100 years later, the Supreme Court finally embraced Harlan's argument. So it's all part of this, it's struggle, it's activism, but it's also a constant constitutional debate, which is fought out on the streets and in the courts, but always slowly, with fits and starts and advances and setbacks, the arc bends, as King said, toward justice.
Well, it just, as you said, it's a, when we're going to talk about the history of our country, we have to understand the full history so we can learn from it. The brilliance in some ways and of what happened with the founding and how all these great ideas were brought together, and then how they weren't applied. And that, why don't we take the rest of our time that we have here, let's transition a little bit more to where we are. So we've got this great foundation. Thank you for laying this great foundation out of our struggles and why the Constitution matters, and why, if we ask the question, who cares about the Constitution, certainly Jeffrey Rosen, the CEO of the National Constitution Center, will be able to answer that question for us and tell us, yes, we should care. And I'm right there with you, my friend. So let's bring it forward a little bit more. And you talked about the failure of the executive branch after the 13th, 14th, and 15th Amendment. You talked about the failure of the Supreme Court, which kind of gets us to our main branches. Today, I have argued that that the roles of those branches as originally established are not being fulfilled, that the institutions in many ways are failing, and it's getting messy between them, and the decisions of the government are happening further and further away from the elected people who are most accountable to the voters, to the citizens, and by the Congress delegating either to the courts, where you see so much pressure around the Supreme Court and so much visibility and angst because, okay, we're going to wait for the court to decide, so our judges are kind of thrust into into maybe, if you will, a bit of what Congress should be doing about making the laws and bringing clarity, or to the executive branch and not just the president or the administration, but the administration, all of the agencies that are making rules and making laws and doing things that impact our lives. How should we think about this? The original idea of the separation of powers and the roles and responsibilities of those three main institutions in our government, and how they may be maybe not applying the original ideas the way that they should, or not as true to the roles that they need to play, and help us understand that a little bit. Or maybe I'm way off base, but if I'd love to kind of have your perspective on what you see from a constitutional perspective.
You're not off base, Doug. You're doing such an important job in calling attention to the ways that the balance among the branches that the framers had in mind has gotten out of whack. Now, people can disagree in good faith about what to do about that. But just as a descriptive matter, as you say, let's go back to the framing and ask what was the expectation about how the branches would interact. We know that the founders thought that Congress would be the most dangerous branch. Madison feared that it would be an impetuous vortex, sucking all into its maw, very vivid language. We also know that because it's the longest article, and it's also the first article, Article 1. It's not a coincidence that Congress shows up first, because that's supposed to be all legislative power is vested in Congress. And they thought that that would be the body that would primarily debate policy and decide how to balance rights and responsibilities and govern in the name of we the people. The president comes next. It's a pretty short article. He doesn't have a whole lot of enumerated powers. The commander-in-chief of the armed forces is the most important. The power to execute the laws that Congress passes. All executive power is vested in the president. That's called the vesting clause. And then a handful of other powers, like receiving ambassadors and making treaties and nominating important officials, including judges, by and with the advice and consent of the Senate. The framers really thought that the president would be a kind of chief magistrate who would execute laws that Congress passed, but not exercise popular power. And again, just being totally descriptive and nonpartisan here, we can say the idea of a tweeting president of whatever party would have been anathema to the framers. It would be Madison's nightmare, because they didn't want the president to be directly communicating with the people. That could lead to demagogues of the kind that destroyed Greece and Rome, where the people were misled by silver-tongued demagogues who played on their passions rather than their reason. All that very dramatically changed around 1912, and it was not a partisan thing. It was both, there were two populist presidents, Theodore Roosevelt for the Republicans and Woodrow Wilson for the Democrats, who insisted for the first time that the president should be a kind of steward of the people, directly channeling their will and embodying their will as the only nationally elected office. And that completely changed the framers' conception from a chief magistrate, which was, that old vision was embodied in the guy who lost the 1912 election, William Howard Taft. And instead, these two new populist presidents had a different role for the presidency. And the presidency, as a result, dramatically expanded, which you can just see from the rise of executive orders. And it's really striking that at the time of the framing, Washington issued about 10 executive orders. That was the kind of average number per two presidential terms. It spikes up to about 50 during Lincoln's time, during the Civil War, because of the exigencies of wartime. goes back down, and then totally balloons up around Theodore Roosevelt. As I said, there it's up to, gosh, I think it's something like closer to 1,000 around then, or the high of 300, 400, and so forth. Then it settles back down, and then under FDR, 3,000. Amazing. And then nowadays it's settled into about 300 a term per president. Republican and Democrat, no difference. It's not like one party is much better at not ruling by executive order than the other. But basically, both parties are turning to executive orders to do what they can't do through Congress, because Congress is so polarized, totally getting stuff out of whack. And then there's the role of the courts, which we can talk about separately if you want, but I better take another breath here and ask, what do you think about all that, Doug, as a kind of description about a confirmation of your argument that things really have gotten out of whack?
Well, I love, I could just keep hearing you talk because I love how you go through things and articulate it so clearly and put it in context for us, because I can't recall what Washington did with his executive orders or how it would go up and down in different times. But the idea that the framers had of the Congress being the center and so powerful, and the other branches kind of more, kind of secondary almost, maybe in that original context, but how we've changed that and the implications of that, it's important to know, because if we don't understand that that's something that has been shifted, then we can't stop and go, well, how's that working for us? Is that making sense? Are we getting away from a king, or are we moving towards that? There's reasons, that we didn't set things up that way. I love, the Constitution. What's the quote? The only king we'd ever accept was Elvis Presley. That was that was the only one we would accept. But yet we move in these certain different directions. Talk about the courts a little bit. Let's go there and talk about how, kind of the legal framework, the appointments, and then the cases, tend to be going there when Congress could review. I would think, help me understand that where Congress could review the issues, on a variety of issues, and just make another law, and establish law, and go from there. But things have just been, it appears, stalled in so many respects, and just kind of kicked to the courts to decide.
Kick to the courts is a great way to put it. Congress paralyzed by polarization, the president trying to rule by executive order but limited in his power, and the courts stepping into this vacuum and deciding all these questions on their own. So again, let's just be descriptive here. Hamilton, in that paper Federalist 78, which is a great one to read. And those Federalist papers are short, and all of your listeners can read them. So just check out Federalist 78. First thing Hamilton says is the courts will be the least dangerous branch because they have neither purse nor sword. In other words, they don't have any money and they don't have any military. They can't force people to obey their decisions. It's just all has to be their legitimacy, that people feel that the rule of law should prevail. And that's why it's so fragile. But it's also the least dangerous branch because Hamilton didn't think that the courts would strike down all that many laws. He did think the courts had the power to strike down laws. Remember, we talked before about Hamilton saying when there's a conflict between the will of the people represented by the Constitution and the will of the legislators represented by the ordinary laws, you prefer the principal to the agent, the master to the servant. So this power called judicial review, the power of courts to strike down laws, is, although not written down in the Constitution, assumed by all the framers. But the framers didn't think they'd exercise it all that much. Here's an interesting statistic. The first time the court strikes down a federal law, Marbury versus Madison, 1803. When does it do it again the next time? Dred Scott, 1857. Not between, for more than 50 years, there's no federal laws struck down. So it's a power that's exercised very sparingly. By contrast, between 1995 and 2006 or so, if I'm remembering this right, the last time I looked, the Supreme Court struck down about 27 federal laws. So you see that the numbers are really going up. And that's just federal laws. When we talk about striking down state laws, the numbers are much, much higher. And you asked, as is such an important theme of this podcast, why should listeners care about, the Constitution? Well, just think about all the issues the court is deciding: gun rights, abortion, affirmative action, voting rights, religious liberty. It's hard to think of an issue that isn't in front of the courts, confirming Alexis de Tocqueville's observation that in America, almost every political issue increasingly ends up as a judicial issue. He said that in the mid-19th century, when things were really heating up and issues from the status of slavery to the income tax are all going before the Supreme Court. So, there's a lot to say about the Supreme Court, and we can talk about all sorts of different issues about how it should decide cases. But just descriptively, we can say it is deciding a whole lot more cases and striking down a whole lot more laws than it was intended to do. And the result is that it's become a political hot potato in a way that the framers didn't imagine.
Yeah. And I think that's the vital element here, that we understand what the framers were thinking and where we are today, to help us understand what we may want to think about, what we believe about how to help our country be better in all sorts of ways. Jeff, this has been fascinating. I know we're going to have to continue the conversation. I could keep going for a long time, but we'll try to bring this session to a close, just with this final kind of topic. As I mentioned, our board of trustees comes from all different backgrounds, different parts of the country, different sectors, and other things. But boy, do we come together when we get there. All those things go away. Talk to us a little bit about the work of the Constitution Center to not only educate and to not only inform, but to create an atmosphere where there's unity as opposed to division. We're experiencing a ton of division, and it seems like every time we get together, we're talking about how it breaks our hearts. Not that there shouldn't be disagreement or reasoned debate or whatever that may be, but you have a wonderful way, and you were in Grand Rapids a while ago, and I think the topic was voting, the Electoral College. And you had a business group, and it's like, who believes that it should be, Electoral College? Who believes the national vote? We had a great debate about it, and at the end, you asked the question, did anybody change their view? And not many people changed. And then you asked the question, do you have a better understanding of the other side? And that's when everybody's hand went up. Everyone said, I have a better understanding. Well, there was no fights. There were no brawls. Everyone came out with a better understanding about something. May not have changed their position, but how do you see the work of the National Constitution Center and the ideas that we're talking about here, bringing people together so we can find a better path forward and become a more perfect union?
Well, first, Doug, I have to say that much of the nonpartisan spirit and comedy and unity of the National Constitution Center board is a tribute to your leadership. You share my view that there should be no politics whatever introduced in the work of the National Constitution Center. Together, we take seriously our mission, which comes from Congress, which created the Constitution Center as a private nonprofit during the bicentennial of the Constitution. I love to recite the mission before all the podcasts and programs and shows because it's so inspiring. Here it is: to disseminate information about the U.S. Constitution on a nonpartisan basis in order to increase awareness and understanding of the Constitution among the American people. So inspiring, such a sacred trust. So how do we do it? Well, together, we ensure that the National Constitution Center never discusses political topics. It only discusses constitutional topics. Now, what does that mean? That's kind of not an intuitive distinction. Constitutional lawyers will recognize it. Law professors use it, but we're trying to get citizens to embrace it too. What's the difference between a political and a constitutional discussion? A political discussion would be, should we have gun control? That's a very hotly contested question. People really disagree about that. We get into all sorts of statistics and, practical questions about whether it works and all sorts of stuff like that. Constitutional question is different. Not is gun control a good or bad idea, but does the Constitution allow it or forbid it? What's so interesting about shifting the lens from a political to a constitutional lens is, first of all, it forces you to slow down. Hey, I don't really know much about whether the Constitution allows or forbids gun control. I'm going to have to start with the text, read the text of the Second Amendment. Then I'm going to have to learn some history. What do the framers have in mind when they pass those words? Then I'm going to have to read some Supreme Court cases. What has the court said? Then I've not only read the majority opinions, but also the concurring opinions and the dissents. And this is such an important part of what we're trying to model, Doug. It's that the Constitution is made for people of fundamentally differing points of view, as Oliver Wendell Holmes so memorably said. There are generally good arguments on both sides of any constitutional question, not only both sides, but all sides. There are all sorts of different views. So you really have to read those majorities and the concurrences and the dissents and understand not just the bottom line results, but also the constitutional reasoning before you can make up your own mind. And if you've taken the time to do all this, and you can't just do it in a one tweet or in a brief Instagram post, you got to dig in. It doesn't take all day, but you need at least, say, 15 minutes to have an introduction to the topic. Hey, you've already learned an awful lot. More importantly, you've learned how much more you've got to learn. You got to dig in deeper and really inform yourself before you can have a settled point of view. And just that process of only discussing constitutional, not political views, bringing together people of different perspectives so folks can hear sides, and asking people to open their minds to arguments on the other side is the core of what we're doing. And Doug, it's so meaningful to do. We do it with our Constitution 101 classes for kids online, which are reaching hundreds of thousands of kids. And I want your listeners to check them out and try to learn from them. We do it on our amazing interactive Constitution, the most meaningful learning platform I've ever been involved with in my life. I know all my colleagues feel the same way. Where we've brought together the top thinkers in America, liberal and conservative, to explore areas of agreement and disagreement about every clause of the Constitution. And again, listeners, just go check that out at constitutioncenter.org. Pick up clause of the Constitution you're interested in learning about and dig in deep. Listen to the podcast. Read the classes, the scholarship. It's just a world of learning. And then we do it on our public programs and podcasts too. So it's a privilege to do all of this learning. And it's also, to use an old phrase that the framers used a lot, it's a duty. They talked about not only rights, but duties. And the duty to cultivate our faculties of reason was one of the primary duties that came from God or nature. That's also the core of the Declaration. John Locke and Francis Hutcheson and Aristotle and all those philosophers the founders relied on thought that the need to exercise our powers of reason to make up our own minds is not only a right, but a duty. So that's why this educational mission is so profound, so sacred, but it's a duty that's really meaningful and exciting and even fun to perform, because learning and growing is the greatest thing that you can do. It's the highest exercise of your faculties of reason. It's such a privilege to have the freedom to do it as citizens. It's also it just blows my mind, Doug, that with the power of the internet and podcasts and all this great technology, the amount of material that we can put online and organize for people to find on their own so they can engage in lifelong learning is so deep. The framers are kind of debating each other. How can I get the latest edition of some book by some philosopher? They got to send it over from Paris. And Thomas and Jefferson says to Adams, good news, I have an edition and I just sent it to you. With us, it's just the click of a button, All it takes is the self-discipline to dig in, to set aside some time for that deep learning, to try to not do the browsing and the quick reaction, the tweeting, but instead the learning and the growing. It's all there. All we need to do is cultivate the habits of learning and the excitement. And that's what we're doing at the Constitution Center. And Doug, it is such a privilege to do it along with you and our great colleagues.
Yeah. Well, Jeff, thank you for that, and thank you for what you're leading. And you're right, the team at the National Constitution Center is just fabulous. All the partnerships you developed around the country, the ability to have many of these discussions and to talk about the Constitution, so we can answer that question, right? We can answer that question that says, who cares about the Constitution? We all do. And the resources that you hit about the interactive Constitution on constitutioncenter.org. That's where you go there for 15 minutes, you'll be there for an hour. You'll start diving into curiosity. Will just be tapped, and there's so much content there, and it's easy to reach. So Jeff Rosen, my friend, CEO of the National Constitution Center, thank you so much for your time. Thank you for being here, and I look forward to having you back, because there's so much more to explore on this topic, and it's so vital for us, as you said, make up our own minds. Dare I would say, what do we believe? Right? I'll give a shameless plug on our podcast too. But your podcast with We the People, again, a great source of learning and insight. So thank you for joining. Thank you for all that you do, and wish you all the best. Look forward to talking to you soon. Thanks, Jeff.
Thank you, Doug. Look forward to our next conversation. Thanks so much.
All the best. Well, that's it for this episode of Believe. Thank you for joining us, and fascinating conversation with Jeff Rosen, CEO of the National Constitution Center. Just a wonderful opportunity to dive a little deeper, and we look forward to more conversations like that. There's so much that we can learn about how to make ourselves a better country, how to be better citizens, and how we implement those things in our communities to improve the lives of all of those around us. But fascinating conversation. Thanks for joining us. We'll look forward to seeing you soon.